Hello everyone and welcome to today's Mondac webinar in association with Anggraeni and Partners, who will provide a comprehensive guide to arbitration practices in Indonesia and Singapore. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Setyawati Fitri Anggraeni is the managing partner of Anggraeni and Partners. Fitri has over 15 years of legal experience, began as a criminal defence lawyer and later specialised in maritime law at Nordisk Legal Services. Her counsel experience spans environmental issues, various arbitration proceedings and contract negotiations. She has advised on high-profile cases, including potential disputes involving the Sri Lankan Navy. Fitri has been a legal advisor to the Cooperative of the Indonesian National Police since 2017. She has shared her legal expertise through various publications. A graduate of the University of Indonesia, she obtained her Master of Law with merit in Maritime Law from the University College London. She is currently a PhD candidate in Maritime Law and Policy at the World Maritime University. Eva Fauzier is a seasoned legal professional with a diverse portfolio of clients, including state-owned enterprises, foreign direct investment companies, and private firms. She has represented these clients in various arbitration and litigation cases across different jurisdictions. Her expertise spans multiple arbitration rules such as ICC, SIAC, BANI, and UNCITRAL rules. Eva's practice extends beyond representation. She leads AP Law's legal lab team, focusing on legal research and publications, particularly in dispute resolution and tort law. She has published numerous articles on arbitration and business practices in Indonesia. Li Xiyan is Registrar of the Singapore Chamber of Maritime Arbitration, SCMA, and is appointed under the International Arbitration Act 1994 to authenticate original awards and certified copies of original awards and arbitration agreements. Xiyan was previously Assistant Registrar at the SCMA and led the Secretariat's efforts in revising the SCMA arbitration third ed rules. Prior to the SCMA, Xiyan worked as an aviation disputes lawyer in an international law firm, a managing director in a healthcare company, and counsel to a listed medical company. Xiyan is qualified as an advocate and solicitor in Singapore and admitted to the practice to the Australian legal profession as a lawyer. Now, before I hand over to the panel to begin today's webinar, there are two housekeeping items. Firstly, for Singapore lawyers who wish to receive CPD points from SILE for attending this webinar, appearing on your screen now is a QR code that you will need to scan. There will be a second QR code shared at the end of the panel's presentations. For you to claim CPD points, you are required to scan both QR codes. So I'll give you a second now to scan those codes. Secondly, you can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and the panel will endeavour to answer as many of those questions as possible during our Q&A session. It's now my pleasure to hand you over to our panel to begin. Thank you.
Thank you very much, everyone, to spend some time to attend this webinar. I will be presenting about Indonesian perspective of arbitration clause. Next, please. Okay, first of all, I think it would be relevant to understand what is arbitration under Indonesian law. In general, it is defined as a dispute resolution method outside the court system based on a written arbitration agreement agreed by the disputing parties. We understand that there are, of course, some benefits of choosing arbitrations, including confidentiality and flexibility, and that keeps arbitration as one of the preferred methods to resolve disputes. Next, please. So, arbitration in Indonesia is generally regulated by Law Number 30 of 1999. On arbitration and alternative dispute settlement. That law defines arbitration agreement, as it is very crucial in arbitration in Indonesia, as an arbitration clause that is part of a written contract that parties enter into before the dispute occurs. Or it can also be a separate arbitration agreement that the parties enter into after the dispute occurs. I'm sorry. So in here, we could understand that the arbitration agreement under Indonesian law must be made in writing, and it can be entered into before or after a dispute occurs. Next. So this table is basically a comparison between the elements of arbitration clauses under the arbitration law and in general. On the ones that we refer to under the arbitration law, we have to make sure the differences between the clauses that is entered into before a dispute occurs and after the dispute occurs. The first one, I will break it down later, but for the second one, for the arbitration agreements for dispute that has arisen, we must take note that it must include these elements. There must be elaboration on the disputed matters. There must be name and domiciles of the parties, as well as the arbitrators. There must also be seats of arbitration, which would determine the nationality of the awards. And there must also be information on the tribunal secretaries' names. And the period of dispute resolution here would mean how long the arbitration should take place. And another part would include the statement of the arbitrators that they are willing to take the case and they're available to handle the case. And the last one about the cost-bearing statement is related to the party statement that they are able to cover the cost of the arbitration. And of course, mutual consent is important under Indonesian arbitration law as well, and I will break it down later. Next, please. So the first three important elements under the arbitration clause under Indonesian law would be consent, choice of rules, and then number of selection of arbitrators. The first one about consent, a clear expression of the parties' intention that they wish to resolve their dispute in arbitration is very crucial for an arbitration in Indonesia, because this would establish the exclusive jurisdiction of the tribunal, and this would set aside the court's jurisdiction over the case. I think it would be relevant to note that in the past there have been precedents where parties could still go to the court and ask the judges to resolve their case even though they have arbitration agreement. But because of these provisions, this should not be the case anymore, because the court's approach should be to reject any matters that has that is covered by arbitration clauses or agreements. And the second one is the choice of rules. This would determine whether the arbitration is ad hoc or institutional arbitration. When parties do not particularly refer to institutional rules, for example, they just mentioned that we agree to settle this matter through arbitration, then as a general application would be the arbitration law itself, meaning that it would be an ad hoc arbitration. But if the parties specify specific rules, they are given the liberty to determine which rules and whether it would be ad hoc or institutional. The third one about the number and the selection of arbitrators, it is regulated in various points in the arbitration law. There is no specific requirements whether the number should be 1 or 3 or 5, but then the parties also have the liberty to determine whether it is 1 or 3. As a matter of practice, actually, it seems that Indonesian parties prefer 3 arbitrators. So I've seen more clauses containing 3 arbitrators instead of 1, even though lately there has been some shift that parties would prefer sole arbitrators here. And the parties also can include the qualification of the arbitrators that they wish to appoint in the future. On this note, it would be important to note that under Indonesian law, if you have an arbitration in Indonesia, then Article 12 of the arbitration law specifically mention about the qualifications of arbitrators. Among others, the arbitrator should at least 35 years old and they have at least 15 years of experience. Whether it would affect the practice, that would be another topic, I think. Next. Another point that is usually included in the arbitration clause would be the seats of arbitration. This is very important, especially within the context of Indonesian practice, because there was a precedent where there was some mix-up about seats and place of arbitration. So having a determined seats of arbitration would be very important. And if, say, the parties agree to include Indonesia or Jakarta, say, as a seat of arbitration, then there would be implication of the enforcement as well. If the seat is in Indonesia, in general, the award would be deemed as a domestic award. Meanwhile, if it is rendered outside Indonesia, it would be generally seen as an international award, and the process of the enforcement would be slightly different because of this decision. And another point that is also very interesting from Indonesian perspective is the determination of language in the arbitration. Maybe some of you are aware that we have language law which requires parties to have bilingual contracts. In practice, it would also affect how the arbitration would be held in Indonesia. If the parties do not specify the proceeding language would be English, then the tendency, of course, it depends on the panels as well. But if it is Indonesian panels, then there would be a tendency that the language would be Indonesian language. So including language of arbitration would be very crucial when drafting arbitration clause. And this one about the governing law of the clause itself, it would be optional. In general, Indonesian law would consider the governing law of the contract would be the governing law of the arbitration clause as well. However, if the parties have a different approach or consideration, then they could also include a specific governing law of the arbitration clause that they agree. Next point. Okay, and the last one, not the last one, the last slide about this, the first point is regarding the cost allocation clause. This is also relevant under Indonesian context because as a general practice, the losing or the unfavorable parties usually would bear the cost of the arbitration, especially in litigation. So if the parties have different concern about this, and there has been tendency that the parties would like to pay 50-50, then it would be important for the parties to include clause allocation clause in the arbitration clause, because this would give certainty about how the parties would arrange payment and who bears what when the arbitration has proceeded. The eighth point is about the finality and the binding nature of awards. Of course, we all know that arbitration clauses final and binding. However, I think this is also noting Indonesian practice again, because some parties may have understood our arbitration award as being able to be appealed, but it's not the case. So some parties would prefer to emphasize the finality and binding nature of the arbitration clause in the contract. So if one day that there would be like improper attempt to challenge the award, then this could be one of the arguments to say that, hey, we have agreed that this arbitration award is final and binding, not only by nature, but also contractually. The last point is about the exclusivity of arbitration clause. This is also still relevant because of the practice of the appealing of arbitration award itself. So by mentioning that once the parties have agreed to arbitration, then the dispute should only be resolved through arbitration would give more, would make the parties more committed into enforcing their arbitration clause rather than trying to go to the court to resolve their disputes. Next point. Okay, so reflecting the points that I have mentioned about the arbitration agreement in Indonesia, basically we can divide each points of the of it as an anatomy of the agreement itself. The first one is about the consent itself. It's about, we can say that any dispute arising out of or in connection with this agreement to be resolved under arbitration. So this is just for an example. And another point about the institutional, about the choice of arbitration rules. For example, there have been choices of arbitration institutional rules. In this case, it could be SCMA, it could be other organizations or institutions as well. And as I mentioned, the number and selection of arbitrators in Indonesia, in general, the preference would be 3 arbitrators, but of course it's not binding. It's just the trend that I've seen from the contracts that I have reviewed in person. Next. Okay, about the seat of arbitration, there is also no mandatory seat under Indonesian law. So the parties could actually have a seat of their choice when drafting their arbitration clause. And it would be very important to determine, especially when you see that the projects in Indonesia, for example, but then the parties are based in Singapore, then you could take it into consideration which seat is more relevant to your contract. About the governing law, that would be the same explanation. If in some cases, some parties, well, some contracts in Indonesia are mandatory to be governed under Indonesian law, for example, construction contracts. But in some cases, they would like their arbitration clause to be in a specific in other law, for example, English law or Singapore law. So that would be possible under Indonesian law. Next point. Okay, this is an example of how the cost allocation clause could be enforced, could be implemented in arbitration clause. It could be shared equally by the parties. It could be said that the losing parties would pay, or any other arrangement as the parties deem fit. And as far as the finality and binding nature, as well as exclusivity of the arbitration award, this forms as an emphasis that the arbitration awards are indeed final and binding, and that the only jurisdiction that binds the parties would only be arbitration and not the other jurisdictions. Next point. Okay, so in general, this is the summary of the elements of arbitration clauses, especially in Indonesian law governed contracts. Maybe quite similar to arbitration clauses in general, but just to say that it is quite flexible, but at the same time, there are some points that the parties would wish to take care of at the beginning when drafting this awards. Sorry, in drafting this arbitration clauses. And just one last note, if these arbitration clauses are set out once the dispute has occurred, then the parties would have to be very mindful that each elements are fulfilled in the arbitration agreement. Otherwise, it could be rendered null and void. So I think the points of drafting arbitration clauses under Indonesian law is just to see that each element is fulfilled and see how it fits to your preference. That is all from me. Thank you for the opportunity to explain this.
So next, thank you everyone for attending this webinar, and thank you Eva for a very thorough presentations on the drafting arbitration clause. So in my end, I will sharing about business approach in arbitration clause drafting from Indonesia perspective. Next, please. So the first slide here is basically providing an overview of ways of or method on resolving dispute in Indonesia. So first of all, just like everywhere else, court is an options for resolving dispute in Indonesia. And Indonesia, as Eva has mentioned, under law number 30 of 1999, providing alternative dispute resolutions, as we can see in the table here. So there is alternative dispute resolution for resolving dispute, and also there is an arbitration. From a business perspective, the considerations can be from the flexibility, confidentiality, speed, cost, and enforcement of decision. So from a court perspective, the decision is open for public access. Meanwhile, in Indonesia, the arbitration award is not open for access for the public, so the confidentiality can be preserved and maintained. In terms of speed, it will be depends. However, it has been general understanding that arbitrations can be seen as a more expeditious because it has no appeal avenue, unlike court, whereas it takes sometimes longer because there is an appeal and also cassation avenue. Next, please. From the business perspective, this slide explains about several numbers of Indonesian law that showing support towards arbitrations. The first table is digital data protection law in Article 64, support in dispute resolutions, and also in construction law in Article 88, basically advocating arbitration as the one method of resolving dispute. And lastly, in law number 4 2023 on financial service, also advocating alternative dispute resolution and also arbitration as another method of resolving dispute in Indonesia. So these two presentation or these two slides conveying that Indonesia is in support towards alternative dispute resolution and also arbitration as a one way of resolving dispute other than court. Next, please. So in this, I think important point that I would want to make in this presentation is there are 9, I would say, business approach that you can consider when choosing arbitrations. So first is understand the business objective. So consider the industry, the nature of the transaction, and the potential dispute that may arise. So draft the arbitration clause with the goals efficiency, confidentiality, international considerations. The second approach is tailor the scope of arbitrations. So in several arbitration clauses that I have reviewed, the clauses usually say that any dispute in relation to this contract or including its interpretations or breaches arising from the contract must be resolved through arbitration. So that specific clause putting a scope towards the issues or claims or dispute that can be resolved through arbitrations. The third approach is choose appropriate arbitration institution and rule. And as Eva has mentioned previously, there is no specific obligations to basically choose a specific institution, for example. So parties can consider whether they want to do ad hoc or institution, but please make sure that you are well familiar with the institutions that you choose. Next, please. The fourth approach is customized arbitration selections, because some would believe that arbitration is preferable because the arbitration is led by arbitrator who has experience in specific industry for a specific contract. For example, SCMA have arbitrators who have focus on shipping and maritime issues. So that will be a very handful and helpful in analyzing the issue and dispute, and parties can basically confident that their issues is examined by someone who is expert in the industry. That will be the benefit also for arbitration compared to court, who has been seen in Indonesia as a more general approach in viewing the cases, because the background of the judges is they need to understand all cases. Next is address specialized industry practices. So there is a expertise for a specific industry in arbitration, so please consider the specialized industry practices. And next, efficient time frames and processes. So if there is a intention of make the arbitration proceedings to be efficient and time oriented, then specific time frame is advisable to be included in the clause. Next. Confidentiality and business interest is also one of the element that is very important in arbitration. So if there is a specific needs for both parties to protect several documentation or how the documents should be presented as evidence, for example, then it needs to be included in the arbitration clause. Global considerations that will relate to enforcement. So if you want to have an award that basically enforced in parties of the New York Conventions, so arbitration is a preferable choice rather than probably court. Also, dispute resolution alternatives. So in several arbitration processes that I've reviewed, before parties initiate arbitrations, there usually amicable settlement process that party needs to perform before then they initiate arbitration. So next, I think that will be the 9 most important business approach from Indonesia perspective to consider when you are choosing arbitration. Thank you.
Thank you very much, Ms. Setchawati. And just to let everybody know, we will be flashing up the QR code again for you. So if you did miss it the first time, please do scan that QR code and you'll be able to receive the CPD SILE credit. We'll keep that up for another 5 to 10 seconds for you. There will also be another QR code at the end of this presentation that you'll be able to scan to receive that credit. So thank you very much for that. And we will now move on with our presentation. Thank you very much.
Thanks very much. I'm Shian from the Singapore Chamber of Maritime Arbitration, SCMA. And before I begin, I just wanted to thank our partners, Anggraeni, for having me today to share a little bit about the do's and don'ts from SCMA's perspective on what good model arbitration clause would look like, and also to Mondac for having me. Next, please. So do's and don'ts in drafting arbitration clauses. Okay, before I share with you our perspective of what we do and we don't, I'm going to show you some examples of clauses that SCMA receives. So next slide, please. So you can see some of them are very brief, with arbitration/London, for example. Another one could look like GA/ARB SCMA rules. Then you might have longer ones. Any disputes arising out of this charter party will be resolved through arbitration. Arbitration applies to disputes related to cargo claims, and you have different variants, right? Many of these rules may or may not work. One interesting one I want to draw your attention to is the one at the bottom right, where it says arbitration rules of the S, and you see the letter L that's been struck out, and it basically reads SMAA, in the belief that if you don't want London rules, you strike out the L for London and you put S, and that would refer to a set of rules in Singapore, when in fact it does not refer to SCMA. So we're going to be talking about arbitration clauses, defective arbitration clauses, and some of the most common errors we see parties or their counsel may make when drafting an arbitration clause. Next slide, please. So what is an arbitration clause? Very briefly, I think Eva has already covered this in her presentation, but essentially, two or more parties agree to allow an arbitral tribunal to privately resolve their disputes, and the key features of the clauses would be it's final, binding, private, and enforceable in a New York Convention state. Next slide, please. So why are arbitration clauses drafted poorly? Next slide. So the unfortunate truth of the matter, especially if you come from a commercial perspective, is that most people don't think of the disputes when you are busy trying to make money commercially through a deal, sale and purchase, right? It's often left to what we call a midnight clause. It's the last clause that you decide on at or just before midnight. And usually, arbitration clauses are drafted by persons who are not very familiar with arbitration. It could be done by someone who only has commercial training, for example. If you're trying to get the deal across the line, you're looking at commercial terms like price, duration, what kind of Incoterms that you are writing into your contract. Most people don't think of what happens if there's a dispute, right? So there's a great focus on commercial decision making rather than looking at what happens if there's a dispute. Other times, right, in a company, you want to try and save costs. So you may not go to lawyers like our partners at Anggraeni and you think, let's go on the internet. And now with ChatGPT and Gemini, I would just throw me an arbitration or dispute resolution clause. And I'll just pick the first one that comes up, or I'll call a friend and say, show me your arbitration clause that you use in your dispute. I'll take that, I will change some of the things that are obvious, and there we go, right? So we call those boilerplate clauses that we just amend slightly. Now, the difficulty with boilerplate clauses is if you're not aware of some of the nuances, for example, that exist between different countries, civil law, common law countries, even between, say, Singapore, Indonesia, right? You could have different local practices that one may not be aware of. Changing that one or two letters or that one or two words may have an effect on your dispute resolution clause, right? Sometimes it could be you're using an old boilerplate or an old contract that you have derived from your predecessor in your company, and those clauses may not have been updated to reflect the most recent changes in law, right? So these are some of the more common reasons, right, why arbitration clauses, poorly worded, poorly drafted arbitration clauses exist. And of course, there's always this perception that lawyers are expensive and they're not needed, or a waste of money, and therefore, we don't spend money to get the clause right. But as anybody who has been in a dispute will tell you, you rather spend the money at the beginning to make sure you have a good contract than spend even more money trying to undo the problems that arise. Next slide, please. So I'll take you through some of the common issues in drafting clauses. So here are some examples you can see, and you can find many of these examples also either online or through your lawyers. For example, where you do not make or you don't word arbitration in a way that suggests it is mandatory. For example, you may say something along the lines of parties can bring the dispute to court or arbitration, right? So that's a non-binding arbitration clause. And in many of these instances, that renders the arbitration illusory because parties have the right to elect between either, right? So these are the cases in which the clause was held to have failed. Next slide, please. Sometimes you may not be aware, next slide, please. Sometimes one may not be aware of a change in institution or the law, or you may be using a boilerplate that you don't quite recognize, for example. So you refer to a party that does not exist or an institution that does not exist. So, for example, in this, the first paragraph that you see on your screen, right? The parties have decided to litigate in the arbitration court of the ICC in Paris, seated in Zurich, right? So there's a question now, right? Because there is the ICC, right, which is not in Zurich, it is in Paris, or there's the ICC, or there's the Zurich Chamber of Commerce, right? So both have arbitration courts. So the question then becomes, which entity did the parties intend to refer to? Another example below would be disputes arising in connection with the agreement shall be submitted to arbitration, shall be a well-known chamber of commerce designated by mutual agreement. So what the parties really intended to say here was to subject themselves to arbitration under the ICC, right? But by referring to them as the arbitrator, which they're not, they are an arbitration institution, you create that question of who did the parties really intend to choose, right? So these clauses will be found to be defective. Next slide, please. Another common issue is to appoint, or rather refer to an appointing body or appointing authority that is not an arbitration institution or does not have in its normal mandate the authority to appoint someone. So in this example, there was a flawed clause that refers to appointment to be made by the Director General of the World Health Organization, who obviously is not interested in arbitration in the way that we are, right? So this was upheld. This was found to be defective. Next slide, please. Sometimes we're not sure why the additional words are there, but we add on to the clause to make it seemingly more complete, right? So in this example, basically, the parties have agreed on the clause that is impossible to give meaning to, because they have now agreed that it shall be subject to the arbitration court of the ICC of Zurich in Lugano, right? So this was upheld as a clause that was inconsistent because it refers to two different things within the same sentence. Okay, next slide, please. The last example I'll show you is where clauses have been added on at the last minute, for example. So in clause 15, you will see in this example, there's an agreement to refer arbitration to the ICC. But if you read the contract, go on to read the contract down, then you will see it says, but actually, the parties agree to submit their dispute to the courts of Singapore for dispute resolution. So now you have a situation where you refer to both arbitration and the courts in the same contract, right? And this can happen if you have different parties responsible for different parts of the contract, right? So then you may have inconsistency. Next slide, please. So this is a summary of some of the key considerations that I think Ibu Eva and Ibu Fitri have mentioned also in their presentations. The key considerations you want to have in your mind when you are drafting an arbitration clause would be, what disputes do you want to submit to arbitration? The substantive or governing law governing dispute or governing the substance of the obligations itself. You have the law of the arbitration agreement, which could be different from the law of the substantive law, depending on how your lawyers or how you wish to structure your contract. You have the rules by which you agree to conduct the arbitration, and then you have the seat. And the seat is important because the seat refers to which courts would you like to submit the dispute to, or rather to oversee the procedure, if there's a dispute in the procedure of the arbitration. Then you have a venue, which is different from seat, that might refer to the physical location of where your arbitration is held, and obviously what language should arbitration be held in. And as you heard from Ibu Eva earlier, that could be certain countries, certain jurisdictions, for example, Indonesia, may have a local language requirement. Next slide, please. So I'll very quickly talk about how to use a model clause, and I'll give you a quick usage guide to the SCMA model clause. Next slide, please. So I've set out 3 boxes for everybody to consider, right? My recommended starting point, even before talking about drafting an arbitration clause, would really be for parties to take a step back and to think about whether or not arbitration is the right dispute resolution mechanism, even before deciding what clause to use. Sometimes SCMA gets references where the parties have actually intended, for example, to mediate or to negotiate, and they are looking actually for a mediator to guide the parties through what could possibly be a quick settlement, right? But by not understanding what they actually want, they may refer to the wrong dispute resolution mechanism, which may incur additional costs for the parties, or which may present an issue as they're trying to resolve it. So the first step for me would really be, what mechanism do you want to resolve your dispute? And there are a few to choose from. Is it negotiation, mediation? Even if it's mediation, is it more facilitative or evaluative? Is it arbitration? Or is there a need to go to arbitration? If your counterparties, for example, are all in the same location as you, perhaps you may want to consider litigation before the courts instead, right? So why choose arbitration would be my first starting point. Second, if you've decided that arbitration is the way to go, for example, because you want privacy, you don't want people to know whom you are making a claim against or who is making a claim against you, or if you want to take advantage of the fact that both countries are New York Convention states and you want to enforce an award against someone outside of Indonesia, for example, you've chosen arbitration. The next question you would have to now think about or consider at least would be, would you want to choose institutional arbitration, non-institutional, ad hoc, and why would you choose any of these models? So just as a very quick example, parties may choose institutional arbitration, for example, if they would like the arbitration process to be structured, and there's a set of rules that governs most of the issues, and they're happy for the institution to be driving the pace of the arbitration, right? So usually in an institution, you would have a group of lawyers, legal counsel, who will look at the matters that are filed before it and to give deadlines, to review certain requests, assist the tribunal in certain matters, right? So that is the default mode of institutional arbitration. For non-institutional arbitration, like SCMA, for example, our arbitration rules are generally thought of as more flexible than institutional rules. The parties get to decide how fast and how slow they would like to take their arbitration. And that might be helpful in shipping or maritime or international trade, for example, where all you really want to do is to file your notice of arbitration against the other party to preserve your legal right of action. But at the same time, you do want to achieve some form of negotiated settlement with the other side. And you don't want to pay, importantly, an upfront fee. So you may choose non-institutional or ad hoc instead. And the last model, ad hoc, obviously, there will be no institutional rules, no institutional involvement, right? You proceed under, generally speaking, the UNCITRAL rules, and parties will have to conduct the arbitration fully together with the tribunal that they appoint. So once you've decided that you are choosing arbitration, you've decided on the model of arbitration to proceed with, you will then review the arbitration clause, as what Ibu Fitri has shared in her presentation earlier, and the considerations that she has laid out. Next slide, please. So on that note, I will show you the SCMA model arbitration clause. You can find this easily on our website, right? scma.org.sg. There's a QR code. This one is not for CPD points. If you scan it, it will take you to our website and you can look at our rules, download our rules and our model clause there, right? So it's a somewhat lengthier clause than that I've showed you at the beginning of my presentation, right? So it reads, any and all disputes arising out of or in connection with this contract, including any question regarding its existence, validity, or termination, shall be referred to, and finally resolved by arbitration seated in Singapore in accordance with the arbitration rules of the SCMA. current at the commencement of the arbitration, and the rules are deemed to be incorporated by reference. So I'm going to break this down for you. Next slide, please. So you recall the key considerations that I talked about earlier on. What disputes are you referring to? So the model clause makes it clear. Any and all disputes, whether it is as part of the contract or arising out of or in connection, it could perhaps refer to the relationships that the parties have, right, with this contract, including whether or not the contract exists and whether or not it is valid or whether it has been terminated. So the scope of the disputes that you are referring to is significantly wider, right? Shall be referred to and finally resolved. And that tells you that this arbitration is not elective, it is not optional, it is final once you resolve it through arbitration. Seated in, for example, Singapore, which means that if you have a dispute about the arbitration process, so not the substantive merits of the claim, but the process of arbitration. For example, you are alleging that the arbitrator on the other side is unfair and not partial and not impartial, sorry. You would have an avenue to submit a claim before the Singapore courts. So seated in Singapore, which means that the Singapore courts supervise the conduct of the arbitration. The next line, in accordance with the arbitration rules of the SCMA, so that tells you what rules you're going to use for the procedure of the arbitration. Current at the time of commencement, because rules obviously are updated, so that goes to the point about using rules that may not be updated, right? And they are incorporated by reference by means of this clause. So this model clause is what we put forth as a more or less complete arbitration clause. And the reason I say more or less is because very sophisticated parties, for example, may choose to carve out certain disputes for arbitration and certain to remain in litigation, or they may choose, for example, multi-tiered dispute resolution clauses, like what Ibu Fitri shared, where, for example, you may choose to go for negotiation and mediation first, and only if that fails, then you activate arbitration as the final step. So this clause represents the main meat of what an arbitration clause should look like. But if you wanted further customization, please speak to your lawyers. And if you are looking for advice in Indonesian law, our partners Anggraeni will be able to help you out with that, I'm fairly sure. So next slide, please. So I just want to talk very quickly, and I promise this is the last couple of slides that I have, on the benefits of using the SCMA rules. So first, we are an institution, but we offer a non-administered model of arbitration, which means that we allow parties to file their notice in response to the notice of arbitration. And basically, parties get to decide how fast or how slow they would like the arbitration to proceed. Then you might be asking, what if I can't agree with the other party? If you can't agree with the other party, our SCMA rules will kick in, take over, and the parties would then be subject to the standard timelines that all arbitrations are subject to, right? So that's the first advantage. The second is that we have a zero cost model. So unlike almost all institutions that I can think of, we do not charge parties any cost to use SCMA rules. For example, you can have an arbitration seated in Indonesia, Indonesian law, conducted in Bahasa Indonesia, and SCMA rules. And there's no charge at all. You pay SCMA nothing to use our rules in an arbitration. The third benefit is for certain claims, and the claim amount is under 300,000 US dollars. For claims that are under 300,000, or if the parties agree in a higher claim amount, you can do what we call an expedited procedure, which is a very fast procedure for you to get resolution of your dispute from commencement to issuance of the award, 77 days or less. So that's one of the fastest set of rules, right? And lastly, the last benefit I can offer you is you do not have to use an SCMA arbitrator. You can pick any of your own so long as parties agree. Next slide, please. So just a very quick primer about what SCMA is all about. So as Ibu Fitri alluded to earlier, we are a specialist arbitration institution. We are focused on maritime and international trade disputes. And the four vector icons you see there are the main users of SCMA arbitration: ship owners, operators, charterers, managers, offshore, insurance and P&I, and commercial trade, commodities, coal, and the rest. We are now on our 4th edition rules, And we have over 140 arbitrators, including arbitrators from Indonesia. And these are the types of disputes that SCMA handles. And you can see that on the screen. Last slide, please. So thank you very much. If you have more inquiries, please feel free to scan the QR code or to drop myself or one of my colleagues an email using the links that you see on your screen. Thank you.
Thank you very much, Lee Ji. It's been an absolute pleasure listening to all of you today. You can see in front of you the second QR code that you will need for the CPD credit. So please do scan that. Whilst you are doing that, once again, I would like to thank our panel, Sethuwati, Eva and Lee, for your presentations today. An incredibly interesting and informative webinar today, and I'm sure that our audience has appreciated your time. So as I say, please do scan that code. We are going to move on to our Q&A session. If you have a question that you would like to put to the panel, please do send it in to us. We have a couple of questions already in. So our first question, I will open this up to Sethuwati and Eva. How do Indonesian laws influence the structuring of effective arbitration clauses? Can you provide examples of arbitration clauses that have been particularly successful and or unsuccessful in terms of enforcement in Indonesia?
So I'll go first. So I think, first of all, we need to distinguish between the arbitration clause and also the enforcement of an award, because an effective drafting of arbitration clause helps the parties to proceed with the dispute resolution in the procedures that they are already agreed to. So the more general clause, or like Lee Xian mentioned, a typo on the institute rules, for example, will create confusion at the beginning of the dispute. Which institution, how many arbitrators, what languages. So arbitration is an procedures to resolving dispute. So the arbitration clause, to make it effective, we need to identify in advance how we want, in a sense, craft how we going to proceed with the dispute. So it's like a procedural rules of resolving a dispute. So first of all, I want to make a distinguish between arbitration clause. And as Lee Xian mentioned, just like SCMA in Indonesia, we have BANI, and every institution usually will have a model clause in which they advocate if parties want to use their institutions, then the model clause is usually provided open in the website. Secondly, about enforcement, I think, in my view, probably the question is more towards award enforcement. So as Eva has mentioned in her presentation, so in Indonesia, there will be enforcement in a national arbitration award or international arbitration award. So the award enforcement is at the end of the arbitrations, when the panel of arbitration or the sole arbitrator has issued the award, and the parties, if the losing parties doesn't comply voluntarily, then it needs to be enforced through the assistance of the court. I think that's my response for that questions. Maybe Eva wants to have her view on that as well.
Just a few addition. I agree with what Ibu Fitri has just explained. Perhaps to see whether the arbitration clause is effective or not is to see whether it can be invoked or not. Because if, for example, you have optional arbitration clause, as Xian has just explained, then it would be quite complicated for the parties to commence the arbitration itself. So usually when the arbitration has proceeded and has resulted in an award, usually the arbitration clause should not be an issue anymore. So I think one of the ways Indonesian law affects the effectiveness would be the practice of the court. For example, say that the court now is quite persistent in upholding the arbitration's jurisdiction. So when the parties have arbitration clause, then even though it's ineffective, then the courts would tend to refer the parties to go to the arbitration. But then in order for it to be invocable, then the parties would have to make sure that the content of the arbitration clause would not clash with the court's jurisdiction. Otherwise, it would be very complicated to start.
Excellent. Thank you very much for that, Eva and Setyawati. We've had a question in from Dhruva, who asks, arbitrators do not know the environment during contract agreement, and indeed sometimes something may go wrong or there may be an error in the arbitration agreement. In such a situation, how would you recommend the arbitrator proceeds? And I'll open that up to the panel.
So maybe I'll go first. I'll share from an institutional perspective. So you're right. I think the arbitrators may not know what is taking place during the contract negotiation and agreement. But the good thing is that I think they are not required to. So arbitrator selection is really, really important. If, for example, you're the company or you're advising a company and you know that the dispute has something to do with, let's say, for example, shareholders agreement, a dispute between shareholders, you would want, if your dispute is subject to an arbitration agreement, you would want to pick an arbitrator whom you know to have experience in helping parties resolve shareholders agreements. So that's one of the benefits of arbitration. You get to choose who you would like the arbitrator to be, or at least specify certain qualities about that person. So then you would go looking for someone with the experience to help you with the dispute.
Brilliant. Thank you very much for that. Looking at the time, I think what we will need to do is look at our closing comments for today. Setyawati, if I can start with you, please, if there is anything that you want to finish with today, or if there are anything that you would like our audience to leave today's session with, please do let us know. I'll hand over to you.
Thank you, Dan. I would like to thank you, all the participants who is attending the webinar, and also SMA, Lysian, and also Eva for the great and thorough presentations today. I hope what we share, even though it's a very brief and short, can give a perspective or additional perspective for the audience here. Thank you very much.
Thank you very much. We will look to close the session now, but once again, thank you very much to our panel for today. Your insights greatly appreciated. Thank you very much to our audience for being with us today. We really appreciate it. We hope we can see you again sometime soon. Thank you very much. Have a lovely rest of your day. Goodbye.
Thank you. Bye.